everyone. Now let's start with the last part of your company's life, that is your member or your transmission of shares or transfer of shares. Now coming to the part of who can become a member and how you can acquire the membership. Now the membership of a company can be acquired through your subscription, that is when a particular company or a particular issuing house, so when they are issuing, at that time you can apply to your memorandum of association and you can apply for the same. Next, for allotment, suppose in the allotment is being made and directly to the company you are applying, and over there they have allotted the few of the shares to you. Next is your transmission. Now we are basically going to in depth talk about your transmission. Now transmission generally takes on the death of a shareholder. Suppose my father is holding a share of a company and unfortunately his death takes place, and that is why automatically after his death, since I am the legal heir, I will get my name registered on that particular shareholder's copy, and on that I will get the right over that particular number of shares, and that is called to be how the transmission takes place. Even through if a person has become insolvent and if I am purchased all those particular assets, then in that case also the transmission takes place. Next is your transfer of shares. Now transfer of shares, when it is being transferred by one person to another, that is either by your selling it off or by giving back to the company, or company is transferring or acquiring the membership. All these ways you are transferring the shares. Next is your membership by acquiring and by the way of acquaintances or estoppel. That means to say, no doubt you were never been interested, but few of the ways you have estopped yourself, you have just proved yourself and you have presented yourself in such a manner that by default you have become the part of that particular company. Next is by joint members. Now joint members, that means to say where my name is there on the share, where in the company through the joint name of any of the other person, and in that manner I can also be called as a joint member of that particular company. So if yes, first of all let's understand, any competent person who is of sound mind, who can do a contract, can become a member of a company. Secondly, when I'm talking about a company can become a member of another company, that means to say I'm A company, I can hold the shares of the B company also. Now, can a partnership firm become a member of another company? Can it buy its own shares in the name of their own firm? No. First of all, understand, since a firm is not an individual person, that's why each individual partner can hold shares in the company, but not in the name of the firm. Third, when I'm talking about a trustee who buys shares of a particular company, again he will become an individual shareholder of that particular company and not overall the whole association. A registered society can acquire the shares in a company. A registered society can acquire because it is having the identity of a body corporate. A non-resident, a foreign person cannot become a member of a company until unless he has been registered himself with the Reserve Bank of India. An insolvent can be called to be continuously as a member of the company until unless a particular procedure has been taken place against him, or until unless his name has not been, his shares are not been transmitted to any other person. A minor can admitted as a membership of a company limited by the shares. He will have limited liability and specifically by means of transfer. That means to say my father is selling off a particular number of shares in my name if I am a minor. So I can be holding a limited shares also. So a particular competent person, a company, of individual member of the partnership firm, a trustee, a registered society, and insolvent, these are the person can hold these shares in their name as a member of the company. Coming to the next part, transfer of shares. Now transfer of shares, this concept as per your 2013 and your 1956 Act, which says a transfer means where transferring is being taken place from one person to another. Now this is called to be as one of the important features of your incorporation of the company. Why? As per your articles of association, as per your memorandum of association, transfer of shares is about to happen, and that is one of the important feature. Then only you can say it is having a public limited shares or a private limited share company. However, the transfer of your public limited shares can be taken place as and when required, but the transfer of your private company is been limited, it has been restricted. Now the transfer of shares is being done by one person to another person by selling it off in the open market, or selling it back to the company, or selling it to the any financial institutions. Now transmission of shares. Transmission of the shares is by the operation of law. Now transmission is basically transmitting in the three below mentioned criteria. Now below mentioned, that means to say I will mention about the three areas under which the transmission takes place. Firstly, on the death of a person or death of a shareholders. Automatically on the death of the shareholder, the main person who was initially there, automatically after his death, his legal heirs will get right over those particular number of shares, and they can get their name registered in the companies. Second is by insolvency of a shareholder. Suppose if a particular person, as I had discussed earlier, if a person becomes insolvent, then if his all assets are being sold off to the other person, the official assignee or the receiver of his property will become the right holder of that particular share on the basis of transmission. And third, if a company which is a shareholder goes into liquidation, then if a liquidating company automatically will be passed on to the other acquiring company. Then if I am the member, automatically on the liquidation, the shareholder rights will be liquidated, and the liquidator is necessary to take all those particular actions, and he will get the right over that particular number of shares automatically, and I will be paid the amount for the same. So these are the three ways under which your transmissional rights of the shares will be passed from one person to another. One is through your death of a person, another is your insolvency of a person, or through liquidation of those particular company shares. Now with this, we have finished up with the concept of your transfer, transmission, and at the same time we have finished up with the concept of your Companies Act 2013. Thank you.